Hi, this is Ken Landau, and welcome back to Law You Should Know. This program is about arbitration agreements, and attorneys can earn CLE credit by listening to this program through the Nassau Academy of Law. You will have to pay a fee, administrative fee to them for the credit. You can contact them at 516-747-4070. That's 516-747-4070, or visit the website on the internet, nassaubar.org. My guests today are Elan Weinreb, and he's principal of his own firm, Weinreb Law Firm in Garden City, Long Island, New York. He also is very involved in arbitrations and is involved with the Nassau County Bar Association ADR Committee. And joining us also is Anna K. Mitchell, who's with Redmond Law, and her practice is devoted to arbitrations. And she also has a Master's of Law degree in ADR and dispute resolution. And attorneys, listen for the code at the very end of the program. One way or another, pursuant to the arbitration agreement, we've had our arbitration, and the parties may or may not like the decision. What can they do about it, Elan?
All right. Well, challenging an arbitration award, generally speaking, is very difficult, and I'm going to let Anna chime in a little bit more about this. But the fact is that if you want to try to go and knock out an award, it's called vacatur of the award, you're going to run into some significant obstacles because there are very limited grounds for doing so.
Yeah, absolutely. Generally, there are only a few very, very, very limited circumstances where you can have an award actually overturned or, go back to litigation. One of which is that it was procured through corruption, fraud, or undue means. Another is that it exceeded the jurisdiction of the arbitrators, or it was a subject that was not properly submitted for the arbitration, or that postponement of an arbitration was actually wrongfully denied. So, and then, in terms of also modification of an award, that's also incredibly limited. So in order to do that, let's say, the award is rightfully before the arbitration panel, there has to be either a miscalculation of figures, or it has to be imperfect as to form, or the determination is something that, shouldn't have been actually decided by the arbitration panel. And in terms of the merits, it needs to be corrected.
And what if there's not quite bias, but there's some type of conflict of interest? Perhaps one of the parties or one of the counsel had some type of good dealings or bad dealings with the arbitrator.
Well, in that situation, you would probably have a basis for a motion to vacate for a vacatur of the award. But again, it would be involved with the issue of disclosures. If there were proper disclosures made by the arbitrators, which is required by all arbitration forms in all aspects, then depending upon the level and the nature of the disclosures, it very well might be very difficult, if not impossible, to challenge them.
And if you've waived it either implicitly or explicitly, should the litigants or the parties ask the arbitrator up front? Is there anything you feel you have to disclose?
No, generally speaking, the rules require the arbitrators to make mandatory disclosures at all relevant points, but obviously before hearings or even
And does it have to be the most minor things? They had dinner 10 years ago?
That's really unlikely.
I'll tell you
more
this
egregious.
much. I've seen certain forums that require their arbitrators to disclose any type of relationship, whether it be financial, personal, social, family, or anything.
Well, I don't remember the outcome, but I know there was a big case that was reported recently in the Law Journal about possible conflicts about arbitrator, and they were seeking to knock out the arbitrator or knock out the award on that basis. And I don't remember the outcome. Anyway, about vacating the award, let's follow up with that.
And that's just something you really want to be mindful of, I suppose, when you're agreeing to arbitration.
And the other thing in terms of a vacatur that you have to realize is that very often whether or not you can strive to accomplish that goal is dependent upon the scope of the arbitration agreement in the first place, which really is what we've been getting to. The point is that when arbitration agreements are extraordinarily broad and they have tremendous reach, it becomes that much more difficult to vacate an award because the courts are going to, first of all, go to their public policy in favor of arbitration, which is spread out through God knows how many cases. And in addition to that, they are also going to state that when parties sign a contract, they're going to go back to the traditional interpretations of contracts principles that we all are familiar with as attorneys. And just for those who are not familiar with them, generally contracts are meant to be enforced as they are read by the parties. The courts are not there to reform agreements. And all of those classic principles go back to say that when you have a broad agreement, you're going to essentially be bound by the terms of that agreement.
And for that reason, should the parties consider limiting the scope of the agreement, the reach of that paragraph?
Parties should absolutely. I mean, again, it completely depends on the nature of the agreement that you're entering into and how much you may or may not want to limit it. For example, if you're dealing with like a construction case, you might really want to consider exactly, the forum, because if you're in front of AAA, for example, or JAMS, they have a lot of people who are really experienced in construction. So you're able to, cater your case to somebody who really understands the issues. I'm sorry.
And they're going to have a specialized panel.
Yeah, specialized panel. That's incredibly important. So in a case like that, yes, you want to be a lot more specific. You want to make sure that your case is going to be in front of the right people.
And do you have to specify that in the arbitration agreement, or by specifying a particular provider, you're getting that automatically?
If you specify a particular provider, those rules are coming in automatically. If you're not, you might want to consider being a little bit more specific.
And sometimes what you could do is you could use the sub-rules within a specific provider's rules to get to that goal for your objective. For example, if you're dealing with AAA, you want to have your arbitration before the American Arbitration Association, you can specifically state to use their commercial rules as opposed to different types of rules. And by doing that, you are very likely you're going to get arbitrators who are going to be familiar, obviously, with those rules, and the rules themselves will lend themselves to more specialized types of arbitration.
And go ahead.
Yeah, I think something that's really important to note, too, is that when you're entering into these agreements, there are some that you can negotiate, and then there are some that you cannot. If you're going to Verizon or some other cell phone provider, you're not going to be negotiating your agreement. You're subject to whatever those provisions are, so just know what they are. If it's something that you actually can negotiate, then hire a lawyer. Spend the time, think about it.
Right. If you're buying a contract for goods or for construction or for, let's say, employment or for some kind of services, it's advantageous to understand and negotiate the agreement, because after you sign it, you have lost many of your rights and your leverage.
And that's why, especially with employment agreements, there's a lot of litigation over whether or not, or class action lawsuits. There's a lot of litigation over whether or not you're subject to an arbitration agreement. And the only way, once you've actually signed on and agreed to essentially evade that process and be able to go to court, is if there's a statute that says the arbitration agreement is not enforceable.
And most agreements say that that the scope of the arbitration is any dispute arising out of the agreement that it's included in, as opposed to any disputes about anything between the parties?
Yes, absolutely.
But you could have it broader?
Yeah, it depends upon whatever the parties want. But generally speaking, usually, and especially in the commercial and business context, it's going to be defined by the scope of the business relationships between the parties. Sometimes, as I was mentioning the case before, the Fujifilm Galeshmal cases, sometimes you have different bodies of law which will determine the dispute based upon what goes on. For example, if you have one set of contracts that was subject to an arbitration agreement versus another set of business dealings or contracts that were not subject to an arbitration agreement, sometimes you will get a court, as the court did in that case, to split the baby. But it's not always the case.
And you've mentioned them before, but just to expand them a little bit, the governing law could be very important. Which state is going to be the source of the governing law?
Yeah, as in any case, and even in litigation, the governing law is extraordinarily important, because the law of whatever state or jurisdiction is going to apply, if you're dealing with an international context, will also determine the power sometimes of the arbitrators.
And also the venue might be important for convenience or for the people on that panel.
Yeah, absolutely. And I have one potential case now where the litigants decided to have their dealings in Florida, but for whatever reason they decided to have any dispute arbitrated in New York. And as a result, you have a situation where their dealings were governed by Florida law, but they are going to be involved in an arbitration in New York.
And we talked about it before in terms of David and Goliath. One party, the legal system is essentially free, and you just have to worry about paying the lawyer who may or may not work on the contingency fee. But if you're bound to an arbitration agreement and you feel you've been aggrieved, let's say you're the small homeowner, it might take a certain amount of money to pay up front the administrative fees or your share of them to start the arbitration proceedings. And it's just something to be aware of.
Absolutely. And the fees are really going to depend, too. If you're subject to an arbitration agreement where you only need to hire one arbitrator versus an entire panel of arbitrators, that's going to have a huge impact on your costs.
But it still may be a few $1,000s as opposed to just a few hundred for buying an index number.
Sure.
We just have very little time left in the program. What other tips do you each of you want to wish your clients knew about arbitration? Annie, I know you represent a lot of construction companies. What's important for them to remember?
Well, particularly with construction, you oftentimes have situations where there are multiple tiers of contracts and privity. So something that you want to pay attention to, especially if you're a subcontractor working on a project, is whether or not the prime contract between the owner and the general contractor requires you to be subject to a dispute resolution process.
And would there be something in the subcontract about it, or even if there isn't, you may be bound by it?
No, absolutely. So for arbitration to be applicable for a subcontractor, it has to be specifically incorporated. So
but just the words arbitration might be enough.
Yes, absolutely.
Elon, what else?
My tip for anybody out there is dealing with arbitration agreements is make sure you have an attorney, even if you are an attorney yourself. Have a second pair of eyes if you're an attorney, reading over the agreements that are going to be negotiated, or alternatively involved in the arbitration if you're already stuck with an agreement. If you are not an attorney, you should definitely, a layperson, you should definitely make sure to have an attorney look over any potential arbitration agreement you'd be signing, and certainly if you're involved in an arbitration, have an attorney representing you.
Because after you sign it, it will be too late.
Yeah, essentially that's what.
And it's a very important clause and a very binding clause in whatever the contract or agreement is.
Yes.
Yes.
Okay, I wish we had some more time. For lawyers out there who want CLE credit, again, you have to do it through the Nassau Bar Association. They're going to charge you a small administrative fee. But the code for the program is MIN 1981. MIN 1981. I'd like to thank our guests, Anna Mitchell from the Redmond Law Firm in New York, and as you know, she represents many clients in arbitration, and also Elan Weinreb of the Weinreb Law Firm in Garden City, Long Island, New York. And thank you both very much.
And just very quickly, Ken, just to wrap up, one thing that we didn't mention, Anna happens to be the co-chair of the NYCLA, New York County Lawyers Association ADR Committee. If you have any questions, you can go through NYCLA to get to her, or alternatively, you can go through me and the Nassau County Bar Association. Their number, 516-747-4070. They have arbitration mediation panels, which are available to the community. Thank you.
Okay, thank you. And you're listening to 90.3 WHPC, the voice of Nassau Community College, also over the air at ncc.edu/WHPC. Please join us for another program on law you should know this same time next week. And also, many of these programs can be found on iTunes by searching WHPC.